incorporation by reference as it's currently practiced, I think, violates the Freedom of Information Act's requirements that incorporated material in the federal regulations be reasonably available to affected persons. These rules are often extremely expensive once one contacts the private drafting organization to ask for a copy. They might be $50 per standard, they might be $100 per standard, they might be thousands of dollars per standard. The only alternative may be to ask for public inspection and to physically travel to Washington, D.C. to visit the Office of the Federal Register. For the vast majority of citizens, this is not going to be a viable alternative. So it's very hard, I think, for a federal agency to argue that these standards are in any way reasonably available to affected persons. There's also a potential violation of the Administrative Procedure Act here. The Administrative Procedure Act requires meaningful public comment on proposed rules. A proposed rule has to be published in the Federal Register, and the public has to get a meaningful opportunity to know the content of that proposed rule and to comment on it. In many cases, when agencies propose to incorporate a private standard by reference, again, there is not public access without charge to the content of that standard. I think there is a very significant argument that that violates the public's right to comment under the Administrative Procedure Act. I think there are also some constitutional problems with with the current practices. One is a due process violation. So it's settled law that regulated entities have to have, quote, fair warning of their obligations before the government can bring an enforcement action imposing sanctions for violating that requirement. If a regulated entity is forced to pay large sums to see the content of a standard, I think there's a significant argument there that the regulated entity cannot have fair warning of its legal obligations. There are also issues, I think, with citizens at large not having access without significant fees to the content of these standards. I think there's a First Amendment argument here. The public is entitled to discuss and criticize government actions. That's at the core of the First Amendment. But it is very difficult to discuss and criticize government actions, like the content of binding laws, if you can't easily access the content of those laws. Those kinds of arguments have in other settings justified courts opening up judicial hearings and holding that there has to be public access to criminal records. I think there could well be an argument here as well that the First Amendment requires some greater level of public access to the content of these rules than we presently have. There may also be an equal protection argument here. I think there's an analogy here with public access to the law to some other core principles of democratic governance. So, for example, in the setting of the right to vote, the Supreme Court set aside a poll tax of $1.50 on the ground that it violated equal protection by burdening the right to vote. There's another case involving filing fees for people who want to run for office. In that case, the court set aside a $700 filing fee for candidates because, again, it violated a core citizen activity in a democratic government. And I think similar arguments could be made about these very significant fees to be able to read the text of the law. So I think there are some really significant legal issues here. We haven't seen them explored in the courts so far, but perhaps we will at some point.